Sorry about that, everyone. And Francisca, thank you for the introduction and for the help. As Francisca said, my name is Marcus Deegan. I'm an attorney with Utah Legal Services, and I'm here to talk with you a little bit about the fundamental basics of the eviction process, as well as some pro tips on how to deal with navigating a threatened eviction or an eviction lawsuit, and briefly touching on the coverage of the federal moratorium on evictions under what's known as the CARES Act. So as a quick primer, as I said, I'm with an organization called Utah Legal Services. We are a law firm who represents low-income individuals for certain kinds of legal issues. We do things like helping people with divorce or child custody issues, access to public benefits like Social Security, consumer debt issues, and most relevantly to my work and to the purpose of this webinar, we do housing issues and specifically defending tenants from eviction. Now, our services sometimes go as far as giving people legal representation in court, but that's not always the case. Most of what we do in the housing team is advising people on how to avoid lawsuits or helping them with retaining housing benefits like housing vouchers and public housing programs. But depending on the circumstances and if we conclude that there is a viable defense, our law firm does indeed give representation in court for people who otherwise qualify under our income and asset guidelines. Right off the bat, I will say that if you are having trouble with your landlord, we at Utah Legal Services always do prefer to engage in preventative law rather than defensive law. Once somebody is in trouble with their landlord, enough for it to amount it into an eviction notice or even an eviction lawsuit, it can be quite hard to extract yourself from that situation. So if anybody seeing this just has a question or a non-specific issue or concern regarding your landlord, please don't hesitate to call us before the issue boils over into something bigger. Our phone number is 801-328-8891. And if you want to be able to try to get legal assistance or legal advice from us, you have to call that phone number during our intake hours, which are 9 a.m. to 2 p.m., Mondays through Fridays. Now, with that bit of introduction out of the way, I now want to talk a little bit about just the basics of the eviction process, what kinds of paperwork you might come across if a landlord is threatening eviction, and a few other matters, along with the federal protections in the CARES Act. So the most important thing to know right off the bat is that before a landlord can throw somebody out, they must get a signed eviction order from a judge. So if a landlord ever threatens that they're going to just change the locks on you if you don't pay rent by a certain date, that is not legally accurate. If they give you the right kind of notice and you don't give them the amount of money they're demanding in that notice within that amount of time, they can't then just lock you out at the end of the notice period, but it does mean that you are then vulnerable to an eviction lawsuit. As far as the eviction notice goes, as previously stated, the eviction notice must come before the eviction lawsuit. That you can't have an eviction lawsuit filed against you and only then have an eviction notice land on you. You have to get the notice first. Now, the eviction notice, that can be served on you through nothing more than just a piece of paper being taped to your front door or stuck in your mailbox. That's as advanced as it needs to be generally for the landlord to provide you with an eviction notice. And the most common way is just taping it to your door. An eviction notice is usually quite brief. Some people get confused between just an eviction notice versus the court papers that actually start an eviction lawsuit. The key for distinguishing when it's just the eviction notice or the court papers generally comes down to just the number of pages. An eviction notice is generally 1 to maybe 3, 4 pages tops. The true court papers, the documents that initiate a lawsuit and put you at serious risk of a judge signing an eviction order, those tend to be 8 to 20 pages or sometimes even longer. And those documents must be served on somebody at the tenant's residence by another person. An eviction notice can simply be taped to your front door. A notice about a court hearing after the initial court papers, that can just be sent to you via snail mail or via email. Any eviction order, likewise, that can just be taped to your front door. But the initial court papers, the documents that start a lawsuit, those actually have to be handed from one human being to another human being. It need not be the tenant themselves, but it can be anybody who's roughly over the age of 14 years old who answers the door at the tenant's residence, the residence that the landlord is proposing to evict them from. Now, what does an eviction notice mean for somebody? Well, as I said earlier, it means that there's at least a threat of an eviction lawsuit. So if whatever the notice demands is not done within the amount of time spelled out in the notice, then an eviction lawsuit may be filed by the landlord. Now, the typical notice specifically for payment of rent, which is the most common grounds for an eviction, typically gives a tenant 3 days to pay up. Now, it should be noted that the day that the eviction notice is posted to somebody's door does not count towards the 3-day window. So for instance, let's say I was given eviction notice today. As I said, today, May 15th would not count. Then day 1 would be May 16th. Day 2 would be May 17th. And then if I had not paid all of the money due and owing in the eviction notice by the close of business on May 18th, then first thing in the morning, May 19th, the landlord would be allowed to file that eviction lawsuit and have a person come to my door and serve me personally with the court papers. Most important thing to know if you wind up receiving court papers is that you have a very hard and important obligation to file a document called an answer, capital A answer, at the courthouse within 3 business days after the date you receive the court papers. So once again, let's say I had already gotten an eviction notice on Monday and I didn't pay up the money. Well, now today would be the day that the landlord could file the lawsuit against me. If I were served with court papers today, knowing that I have 3 business days after today, meaning today does not count, well, tomorrow, May 16th, and then the next day, May 17th, those are weekend days. Those don't count as business days. So then I would have Monday, May 18th, Tuesday, May 19th, Wednesday, May 20th would be my deadline to file an answer. Now, it's always best to use a form answer, which you can find at utcourts.gov. You can also just do a simple Google search for UT Courts as one word, and then a space and the word answer. Or even better, UT Courts eviction answer. And you'll see a page from the Utah Courts website with a court-approved form answer that also includes some instructions drafted by my office. And those will walk you through step-by-step how to fill out your answer form. Now, after that, then the landlord has to ask for a hearing in front of a judge before the eviction order can be signed. Crucial to note, the reason why I was saying that it's so important to file your answer on time is because if you don't file your answer on time, then the landlord can ask the judge for an automatic win, what's called a default. And when a default is entered, a landlord can get an eviction order almost immediately, and a person can be thrown out sometimes in as little as 24 hours, or usually not much more than 3 days after the judge has signed the order. So that's why it's so incredibly crucial to file your answer on time. If an answer is filed even a day late, the judge is allowed to sign a default and an eviction order immediately. If you do get your answer filed on time, then a hearing is going to get scheduled. Once again, it is very, very important you attend that hearing. Keep in mind also that right now, because of the COVID crisis, a lot of court hearings are being held over the phone rather than in person. So you need to make sure that if you put an email address on your answer form that you filed with the court, that you may be getting an email from court staff saying that your hearing has been scheduled for this date and this time, and you need to call this phone number for being able to attend your hearing telephonically. If you don't have a telephone or access to a telephone for some reason, you do have the option of appearing in person, but in the name of personal safety, it's always best to try to appear by phone until this COVID crisis has calmed itself. So that is a quick overview of the process. And then at the court hearing, if you have evidence in your defense to prove I never owed this money, or this money that they're claiming I owed, I paid in full and I don't owe any other money, then the judge would decline to enter the eviction order. However, if the landlord can prove that the money is indeed owing, then the judge will have no choice but to sign an eviction order. And it should be noted that things like being in extreme poverty, or being disabled, or being elderly and having very few resources, or anything else like that, those won't be grounds to stop the eviction. At most, you can present those facts to the judge and ask that the eviction order grant you more time than only 3 days, which is the usual duration of an eviction order. But if once the judge signs the eviction order, that will be the end of the story, and you will have to vacate within the amount of time described in the eviction order. So now with that, I've captured the basic process, but I want to go back all the way to the beginning, what I was talking about with just getting that the initial eviction notice. Nothing in the courts is initiated. You just got a piece of paper saying if you don't do this, then there will be a lawsuit initiated. It's very important that when you get a document like that you try to communicate with the landlord. I personally, when I am consulting with my clients, I usually recommend that people try to communicate with their landlords via email. So that way, anything that's agreed or not agreed to is in writing. But that said, if it has always been your normal practice to communicate with your landlord in person or over the phone, you can do so. It would be best to have a friend or family member present with you for that phone call to act as a witness in case there winds up being any dispute about what was said or agreed to during any of those communications, either over the phone or in person. But what matters is more than any of these other details is that you communicate with your landlord, email, phone call, in person, what have you. But let the landlord know what your situation is. And if it is a matter of non-payment of rent and you just simply don't have that money, then you need to let the landlord know what steps you're trying to take to come up with that money. Because on a legal level, there's no defense to non-payment of rent. If you owe the money that they say you owe, then the landlord will be able to successfully evict at some point or another. And so if you are behind in rent and you believe you will be able to come up with that money, you should make sure to let the landlord know and give the landlord a sense of about how long you think it will take to come up with that money. And if you're not sure of how long it will take, but you even just have a rough estimate, let them know that. Don't leave the landlord just guessing, when am I going to get this money? Because if they just have no idea, then they're going to assume that they're never going to get it, and they'll just file the eviction lawsuit. Some landlords will work with tenants who give them adequate notice that rent is coming late. Now, be forewarned, though, that plenty of leases say that a landlord can charge late fees for rent that is not paid on time. And even if you are fully and adequately communicating with your landlord, that doesn't mean you're absolved of that obligation under your lease agreement, and you will still have to pay not just the rent owing, but those late fees that were tacked on. And for that matter, you need to be prepared to continue to pay rent for those months in the future. Now, that gives a basic sketch of the eviction process. And I now want to discuss a little bit about some special protections that have been afforded by the federal government under, as I referred to earlier, it's called the CARES Act, all big capital letters, C-A-R-E-S, CARES Act. CARES Act is the big, what's been sometimes referred to as the bailout package that was passed at the end of March of 2020, meant to address many of the economic crises currently hitting the economy from the coronavirus. The CARES Act only extends to protecting certain kinds of renters, but for those renters, it provides a quite substantial amount of protection. Now, first and foremost, the CARES Act only covers a tenant if A, the proposed eviction is based on non-payment of rent, which is to say that if your landlord has some other reason for bringing an eviction lawsuit against you, for instance, they claim you're breaking some rule, you're not cleaning up after your dog when you take him outside, or you've got a family member staying with you who isn't on the lease, and the landlord never gave you anything in writing saying, yes, that family member can stay with you for an extended period. Or you're smoking inside the unit or nearby the building, or you committed a crime on or near the building. These would all be grounds for eviction for which the CARES Act does not provide any protections at all. Second of all, the CARES Act only protects people for non-payment evictions if the landlord is in some way benefiting from their mortgage being federally backed in some way. So many many residential mortgages are backed by the federal sources, Fannie Mae or Freddie Mac. If your landlord's mortgage is backed by Fannie Mae or Freddie Mac, then the CARES Act might apply to you if the only grounds for eviction is non-payment of rent. Likewise, if your landlord took out an FHA, Fair Housing Act loan to help get the mortgage for the property, likewise, that might provide for further protections. You can find a database that has been put together by the National Low Income Housing Coalition by, let's see, I unfortunately am unsophisticated enough with Zoom to not have ever done a screen share before, but if you do a Google search for N, like November, NLIHC.org, and then the words federal moratoriums, then it should be the first link to pop up. And that link will have a database of landlords from all across the country, even including Alaska and Hawaii, and indeed our own state of Utah, listing what landlords out there have in some way benefited from a Fannie Mae mortgage or a HUD mortgage or a mortgage backed by the USDA or some other source. And if your specific apartment complex shows up on that database list by the National Low Income Housing Coalition, then you might be protected from eviction right now. However, very, very importantly, I should emphasize that even people who are covered under the CARES Act, still, they are not immune from being sued for an eviction eventually. The federal moratorium ends on July 25th of 2020, which means that if you have suffered a financial crisis and are unable to pay rent and have been unable to pay rent, come July 25th, you will be considered legally liable for the full amount of rent still unpaid. If you're unable to pay it, then you will be likely to suffer an eviction lawsuit. And as I said before, there's no defense to an eviction lawsuit other than proof of payment. So if by July 25th you can't come up with all of the rent due, then once again, that goes back to needing to communicate with your landlord to see if you can work out some sort of a rent deferral agreement or some sort of other repayment plan to get caught up on your rent. You can find a model rent deferral agreement on Utah Legal Services website. Just go to Utah, the full word, UTAH, utahlegalservices.org. And along with that rent deferral agreement form, you can also find some other free information that we have made available to the public in case you have other questions about the nature of your housing or any other problems you are facing. Let's see, I believe that may cover everything that I wanted to address. Yes. All right, that does cover everything. So with that, I will simply give as a reminder to, if you are having an issue with your landlord, please contact Utah Legal Services. We cannot advise everyone. We can only help people who income and asset qualify for us, but we figure that step of the process out first thing when you call us. Our intake line is open from 9 a.m. to 2 p.m., Mondays through Fridays. And if you do income and asset qualify for us, we can at least give you legal advice on how to navigate whatever problem you're having. And if you have a defense and wind up getting sued for eviction, then we might very well be able to provide representation in court. Please do keep an eye out for us. Thank you very much for your time and attention. My name is Marcus Deegan with Utah Legal Services, and I wish you well, and I hope you're staying safe. Take care.